Good morning, ma'am. This is Judge Jessica Green, Jefferson Division, Circuit Court Division 6. I'm here for a hearing, and Mr. Gorman was supposed to be here. Oh, you, Mr. Gorman?
Yes, I'm sorry.
Okay, all right. I've been sitting here waiting. All right, come on down. All right, I apologize. All right, okay.
Sorry about that.
Thank you.
We've not met before. My apologies.
All right, come on down. All right, come on, guys. Let's get on the record.
Whichever side you want. Okay.
All right, good morning, everybody. We're on the record in the case of 19 CI 03088, Kimberly Johnson versus Jefferson County Public Schools. Can I have appearances for the record, please?
I'm Kimberly Johnson.
Good morning, ma'am.
Tyson Gorman here on behalf of the defendant, Your Honor.
Good morning, counsel.
Good morning.
All right, so let me say at the offset that I have two orders of dismissal in front of me. One is an order of a dismissal with prejudice on this case. And so let's see, I've got a February 3rd, 2022 order of the court that dismisses. Then I've got a March 10th, 2022 agreed order signed by both attorneys dismissing with prejudice. A dismissal with prejudice is a final order of the court, meaning that plaintiffs are barred from bringing an action on the same claim. It's a final judgment. So I need for you, Dr. Johnson, to tell me what authority I have at all, because I do not believe that I have any. I have reviewed your motion, and I'm not making any opinion based upon the facts, even if I view them to be completely true. These are claims and facts that could have and or should have been known at the time that this case was litigated and at the time that an agreement was reached. I don't know what authority I have, ma'am, at this time to go back in and to set aside a dismissal with prejudice. Are you aware of any that I may not be aware of?
First, with the dismissal, the order that Judge Stevens signed, the dismissal with prejudice is not the correct order. My name is actually misspelled on that. That was changed, and that is in their record is not the same, and in my record is not the same. So that's already evidence that that's not even the right order.
Okay, so I would tell you that an incorrect spelling of a name does not in itself make this order invalid, particularly with me not having anything in the record that is a motion to alter, amend, or vacate, which has to be filed within 10 days or becomes final. So again, I'm struggling at this point, ma'am, and to even
Judge,
know,
another thing.
Hold on.
Okay.
I'm struggling to be able to figure out authority I have to set aside a dismissal with prejudice a year and a half later. Yes, ma'am.
Okay. I did not find out about that wrong order that was put in until I received it after July 6th. And the settlement that was signed was improperly notarized. I never signed that settlement in front of a notary. And so that last page of the settlement was wrong, it's fraudulent. And also the first page was changed and some other things were not changed. So it's a whole fraudulent settlement. And I don't know who notarized it. I never stood before a notary. I don't even know that person. I've never seen that person. We didn't do it on a Zoom. I have no idea how it was notarized without me being in the presence of the notary.
Any response, Counsel?
Well, Your Honor, obviously the issue of signing the settlement agreement is an issue between Dr. Johnson and her counsel. I don't know exactly how the signature was obtained. I don't understand her to be saying, though, that she didn't sign the agreement. I think she's taking issue with whether it was properly notarized, but that's frankly irrelevant unless she is suggesting that she didn't, in fact, sign it. And I think she did sign it. I think that is clear from the documents that she herself tendered along with her motion. There were a lot of those documents, but if you go through them, there is a series of text messages that Dr. Johnson tendered to the court that were text messages between her and her former counsel, Ms. Shrewsbury. Obviously, those were privileged before she tendered them to the court, but she has tendered them to the court. It is clear from those text messages that beginning shortly after I sent a draft of the agreement to Dr. Johnson's counsel, again, Ms. Shrewsbury at the time, they began having extensive conversations about what was and wasn't in that particular agreement. She indicates in those text messages that she has carefully read the agreement. She questions why certain things are and aren't in the agreement. And then that text exchange ends with, "I'm ready to sign." That's the final thing at the end of that text exchange. And so as far as I know, while whatever their issue might be as to how and when a notary added his or her certification to that document, ultimately it is Dr. Johnson's signature, and that is really all that matters. And if she signed the agreement contains loads of, as we pointed out in our written brief, numerous cautions and suggestions that if anything is not understood, if there's anything not in the agreement that she has questions about, to raise that. And then ultimately, we end up with a signed agreement. And Your Honor, all that agreement calls for is for us to pay money to Dr. Johnson, us being the district and the defendants, to pay money to Dr. Johnson in exchange for a release. That's all it says. Doesn't call for anything else to happen. Part of that exchange between Dr. Johnson and Ms. Shrewsbury in those text messages about how she thought maybe it should have some other things in it. Those weren't in it. She clearly knew that. That's why she was raising the question of why it wasn't in there. And ultimately, the decision was made to sign the agreement as is. And again, as far as I know, that's her signature. That's what it was represented to be by her counsel, based on her counsel's representation, that was Dr. Johnson's signature. We paid the amounts called for by the settlement agreement. Those checks were cashed, and this case was dismissed. And as Your Honor pointed out at the beginning of this, I'm not really sure how we're here talking about a case that was closed 16, 17 months ago with prejudice by Judge Stevens. I think before we can frankly should be having any of these conversations, Dr. Johnson would need to meet the requirements of Rule 6002, which, as you know, are fairly substantial hurdles to get over to reopen a case. So I don't think we have any basis to reopen the case at all. And I also believe that based on what we know, it appears that Dr. Johnson, regardless of whatever this notary issue may or may not be, she signed the agreement. She understood what she was signing. That's clear from the text messages that she tendered attached to her motion. I'll leave it at that.
So Dr. Johnson, let me hear from you, because I think what you initially filed was that there was you believe there to be a breach of contract here with, so tell me. And again, I'm leading with the fact that I do not believe that I have any authority to even touch this case, even if I wanted to, because this case is dismissed with prejudice. And
Okay.
that means you don't get to go back in on issues that have already been touched and litigated. That's the law. But I do want to hear from you, and I want to give you the opportunity to put on the record what your concerns are. I feel pretty strongly that I have a good grasp about what dismissal with prejudice means. I promise you that I will do my due diligence on this. I at this point just don't believe, even if I wanted to, ma'am, that I have any legal authority to set it aside. But let me give you the opportunity to go ahead and put on the record what your concerns are, what you feel the breach was, what you feel that should have been done that was not done.
Okay, I gave you all the evidence that I actually signed a document, a settlement agreement on February 25th, 2022. And that is the day that I emailed my signature for that settlement. That settlement and the one that was, I guess, submitted to whoever, and notarized, it was on February 28th, 2022, so 3 days later. And it was different from what I signed. And I did not know this until February 23rd, 2023, this year. So when I asked JCPS to please send me a copy of the settlement agreement that they sent to WDRB, And that is
Can you
when
tell me specifically what the differences were, ma'am, between what you signed on February the 22nd versus February 28th?
Yes, it had the 25th on the first page written in, whereas the one that they have has the 28th typed in.
Okay.
And then I had scratched out some things and wrote in some things, which I put in the text message that I wanted my attorney to add to the settlement. That was not done. It's not the same. It's not typed in and added. And then I like the signature page. He took the signature page off the 25th document and put it on the 28th document.
Okay. So essentially what you're saying is you believe that there are underlying issues with your representation of your attorney, which I deem to be a separate issue than you asking me to kind of go back in right now. At this point, there's a process and procedure you kind of got to go through with where there are issues with your lawyer. That's a separate issue from me having any authority right now to go back in and just set aside a 17-month-old dismissal with prejudice. You following me? And again, I don't know. I'm not disputing. Whoever I've got who's here, who's not on mute, if you would please mute yourself, I would greatly appreciate that. Thank you. I am not disputing anything. Let me, whoever's continued to remain unmuted, I'm asking you as a courtesy, if you would mute yourself, I will either do it for you or move yourself. We're in the middle of a hearing. Thank you very much. I'm not disputing anything that you may be saying. I'm just telling you, I don't believe that I have any legal authority to do anything about that. The law does not allow me to go back in and set aside this agreement as a dismissal with prejudice. And you have to pursue some sort of other legal avenue. And there may be other avenues available for you, but I don't have any authority to do anything about this.
Okay, I don't understand because the defendant sent Judge Stevens an email saying it was settled on February 21st, 2022. And I didn't even have the settlement on that day.
And again, I don't know anything about emails. A lot of times attorneys talk about things. They may believe that something is heading in a direction of a settlement. My position has nothing at all to do an email with Judge Stevens. My position has to do with an entered order of this court. It is an agreed order of dismissal with prejudice between the parties. Nothing to do with an email.
And I can clarify that, Your Honor, that this case literally was one that settled on the courthouse steps, if you will. It was scheduled to start at a trial on a Tuesday before Judge Stevens. It was settled at plaintiff's counsel's office, at least on an oral basis, that Saturday morning. We gave the court a heads up that both parties agreed that the case had been settled and that the trial did not need to go forward on Tuesday. That was done with, again, Ms. Shrewsbury's agreement that our office would call and advise Judge Stevens of that so that he could clear his calendar starting for that Tuesday morning. It is true that ultimately the settlement agreement took another few days for someone to put pen to paper. But that is why that information was given to the judge, all of which, as you know, was very standard, was simply a heads up given to the court that a settlement agreement would be coming. And again, I think the key issue is in these text messages where it is very clear that Dr. Johnson took a look at the agreement, read it, understood what was or wasn't in there. I think we're now hearing that there's some sort of debate between her and Ms. Shrewsbury about what should have been in there from the defendant's perspective and certainly the court's perspective. Everything was done in the context of the agreement says only that the defendant is paying money. It doesn't say anything else. In return for that payment of money, the case will be dismissed with prejudice, and that's exactly what happened. If there is some dispute that something else should have happened that's between Ms. Shrewsbury and Dr. Johnson, well, I think that's where that lies. But
Your Honor,
I think Your Honor is absolutely correct. I don't think this court has any jurisdiction at this point to look into that.
Yes, ma'am, Dr. Johnson.
I don't understand how the defendant can tell the judge that a case is settled before it's actually settled. before the terms are actually settled upon. I don't understand that.
Well, that's not something for us to kind of get down into to the weeds upon. That's not really germane at all to this case, whether or not there was an email prior to the settlement agreement. I don't care about an email. What I care about is an order of the court, an agreed order of dismissal with prejudice. Let's get rid of emails. Let's not even work with.
In the text message, she also tells me that the case can be opened at any time if they were to do anything against me.
And again, that may be a separate issue with you and your lawyer. Literally, the very definition of a dismissal with prejudice is that a case cannot be reopened based upon the same issues. That is the very definition of it. It is a final order of the court. And you cannot go back in and relitigate things that could have and should have been addressed during the pendency of the action. That is the very definition of it. And so if you were told something different, I'm sorry. I really am sorry. And it sounds like there may have not been a meeting of the minds. And again, if there's something else that you want to pursue, and again, I've read it, you were talking about whistleblower actions and all that kind of stuff. There may be something else that is out there for you. But in terms of my ability to go back in right now and to do anything about a case that I have no jurisdiction over, unfortunately, I cannot do that for you, ma'am.
Okay. Then we can go with new stuff that has happened after the settlement agreement.
So if there are new things that need to be addressed, you may want to consider filing a new action if you feel that something is there. This case is over. Okay. So we don't get to go back in now and say, okay, well, now I want to add more things on top of this case. What was balled up into this case is over. And again, if there is a new case, you are welcome to pursue that. If that's something that you feel that you want to do, and if there's a legal standing for that, you can do that. I just don't have any authority for you to do anything on. Okay.
Okay.
Yes, ma'am. Do you have any, while you're here, you have any other questions or anything else, ma'am, that you'd like to get off your chest at all this time?
So the new things, even though they're connected, they're continuing from this. It would be a whole new.
It would have to be. This case is over. Yes,
Okay.
ma'am. This case is done.
All right.
Okay. All right. Thank you, guys. I appreciate you. Have a great day, everybody.
Thank you, Judge.
Thank you.
My apologies again for the confusion.
That's
at the
okay.
beginning.
No, it's all good. No, thank you. All right, who's next?